Good afternoon, everyone. Welcome to our webinar focused on the immigrant visa options for IMGs. My name is Naveen Bora. I'm a partner at Woolstorff Rosenthal based in our New York office, and we also have an office in Los Angeles and Santa Monica, California. Today's webinar is really focused on the different visa options for when you're starting your residency program or you're thinking about transitioning from finishing medical school onto what your options are for either doing research in the United States or doing clinical training in the U.S. and what the visa options are and the repercussions of the different visa options. We'll also talk about some issues and problems that may arise that you should be aware of. With the match dates coming up soon, this is really great that you've logged on to listen to this because there are certain issues that you should be aware of once you know you've matched into a program. Now, these are the most common visa options for physicians. I'm sure most of you are aware of the J1 and the H1. They're the two most common, but there are also other visa options such as the O1, which is for people of extraordinary ability in the arts or sciences. The O1 is really for somebody who's further along or advanced in their career because you do have to show that you're at the very top of your area of specialty. So that might be an option when you're further along in your career training. The TN is the Treaty NAFTA, and it's for people who are either Canadian or Mexican citizens, and it is limited to teaching and research. So if you are interested in doing some research with a medical center in the U.S. and you're Canadian or Mexican, then this might be a great path for you to be able to do that research. The E3 is another temporary work visa, but it is limited to Australian citizens, and it's a great work authorization, but again, it's limited to Australians. Okay, so we'll start with the J1, which is the most common visa classification for residency or GME. The J1 is based really on receiving the DS 2019 form from ECFMG. So once you've matched and you've got your contract, you'll go through the process with ECFMG to receive your DS 2019. You will need to show your USMLE steps and a statement of need from your home country. And then once you have this DS 2019, then you're ready to then go and apply for your visa directly at the U.S. consulate or U.S. embassy in your country. You don't need to have an approval from USCIS. It is possible to remain in the United States and change status to U.S. To the J1, and for that you would need to have an approval showing your change of status from USCIS, but if you're going to go straight for your visa, then there is no approval needed from immigration. The other great factor with the J1s is that the spouse who comes on a J2 can apply for an employment authorization document, and we often see couples where one is a principal J1 is doing residency on J1 and the spouse is doing residency on the J2 EAD. Just a word of caution that sometimes timing can become an issue if the J1's finishing up the program and is ready to start a waiver job and needs to transition to an H1, then the spouse can no longer extend the J2 EAD, and there might be a disruption in the work authorization for the spouse who is doing residency on the employment authorization document or EAD. The other big issue with the J1s for clinical training is that you become subject to the home residence requirement. This becomes automatic as soon as you enter the United States on the J1, and we will talk about what this means further along in the webinar. The other issue is what we refer to as a 214B issue, and this is specifically for when you're applying for a visa for the J1 visa stamp at the U.S. consulate. You need to show that you have a lot of ties to your home country, that you will return to your home country when you've finished your training in the U.S. and your home is not in the United States, but your actual country of origin where you've been residing. And for that, you should, when you go to the consulate, show that you have strong family ties or property or bank accounts, things like that. Those should be part of your visa application package when you go to the consulate. The other issue that you should keep in mind is that the J1 for GME is limited to 7 years of progressive training. So if you are going from the for like a long track where you have several years of training, such as surgery, then you may not be able to finish in the 7 years, and then you would have to seek extensions for an 8th or 9th year and show that there's exceptional need for that further training in your home country. So it is possible to go beyond the 7th year, but you do need to get support from the home country to show the exceptional need. The other factor about this progressive training is that if you match into a prelim program, and then you need to get a categorical program for year 2, ECFMG wants to make sure that there's going to be progress, that you're not doing PGY1 years repeatedly over and over without the possibility of a categorical position. So you do need to show continuity, that you're continuing to progress. The other factor that you should keep in mind is once you've got your DS 2019 and you want to then acquire the J1 status, there are ways to do it within the United States through change of status. The change of status process can take a while. It's the application form is the I-539. There is no option to request expedite or premium processing, and so you really are at the mercy of whatever USCIS's processing times are. With the Vermont Service Center, they're now taking several months. The California Service Center has been a lot faster, but you should keep that in mind, that if you are, by the time you receive your DS 2019 and it's the end of April, you may not have enough time to get your J1 change of status granted by immigration to start your program mid-June or July 1. For those who are going to go back to the consulate for their J1 visas, some people become subject to extended security or background check, and that could also be a delay, but for the most part, consular processing is a lot faster than doing the change of status within the United States. You can also get a J1 visa for research, but it is also possible to become subject to that two-year home residence requirement if your country is on the State Department skills list. So if you're from a country where the State Department feels that there's a real shortage of skills, in medicine or the sciences in your country, then that could be a basis for becoming subject. Also, if you receive any form of government funding, either from the U.S. government or your home government, then you would also become subject to the two-year residence requirement. Especially if you get any kind of Fulbright, then those are very hard to overcome with a waiver. In the research context, the DS 2019 is issued by the university or the medical center, and if you're doing J1 research and you want to transition to residency, it is possible to go to an H1B if you're not subject, or you could go to the J1 for clinical training, and but then you would have to show to ECFMG the nexus between the research that you were doing and the clinical training that you'll be gaining through your residency program. All right. Now, what is the two-year home residence requirement, and what do you do if you're subject? The law basically mandates that a J1 physician who comes to the United States for graduate medical education cannot obtain an H visa or an L visa or a green card before going home for 2 years. You're also not eligible to actually change your status in the United States to a different visa classification, such as an O1, you would have to go abroad to a U.S. consulate, get your visa, and then come back in. So it is possible to get these other visa classifications, such as a J2 or an O1. However, you cannot ask immigration to change your status within the United States. You do have to go back to a consulate, get your visa, and then come back. If you are subject, then well, you find out if you're subject. You're definitely going to be subject if you're doing GME or residency, but you can also become subject, as we mentioned, by being on the skills list or getting any form of government funding. J2 spouses also automatically become subject if they're, if the spouse or the principal J1 is subject. Okay, if you are subject, then you can obviously go home and show that you've been back in your home country for an aggregate of 2 years. But just keep in mind that this has to be in the country of last permanent residence or citizenship, the country that's identified on your DS 2019. You can postpone this requirement by obtaining another visa classification, such as an O1 or an E3. However, this 2-year residence requirement will be there, and you won't actually be able to transition to a green card until you've either fulfilled that 2 years abroad or you've received a waiver of that 2-year residence requirement. Again, if you just keep in mind that you do need to go back to the home country or the country of residence. You can't go to a third country such as Canada or the Middle East if you're not from that country as your country of origin. And then you can also fulfill this in aggregate over several years. And you just have to be able to document the actual dates that you were in that country. So be sure to keep really good records of the time that you spend back in your home country. If you are going to postpone it, that's fine, but you do need to make sure that you're not asking for the change of status, that you're actually going back to the U.S. consulate to get your visa and then coming back. Now, these are the most common waiver programs. If you decide to apply for a J1 waiver, they are based on a recommendation from a government agency in the U.S. The most common one is the Conrad State 30 waiver program. This is where you agree to work in an underserved area in either rural or urban, but it has to be a HIPSA area in any of the states. All of the states participate, and most of them give preference to people who do primary care, and then some of them do set aside a few of the 30 slots for specialists. The other agencies that support IGA waivers are the VA, and then if you fall in any of these regions, like such as the Appalachian region or the Delta Regional Authority, you can also get an IGA waiver through them. You can do a waiver through the HHS based on working in primary care in an underserved area or based on doing your research. And the HHS waivers based on research are really, really high level of achievement, and it's more than being able to qualify for an O1 Extraordinary Ability Visa. You really have to show that you play a critical role in some major research project. It's really helpful if the research, that you have got some grants from the NIH, and that there's real national interest for you to be able to continue the research that you're doing, and that it really would fall apart if you need to, go home for 2 years. The other waiver programs are based on hardship. So for that one, you would have to have an anchor relative in the United States, such as a spouse or a child who's a permanent resident or a U.S. citizen, that they would suffer exceptional hardship if they were to go and live with you in your home country for 2 years, or if you were to go for 2 years and they were to remain in the United States without you for those 2-year period. There's also a persecution waiver, so that one is similar to an asylum application in that you would really fear for your safety and your life if you were to go back home for that 2-year period. All right, we're going to move on now to the H-1B visas. This is the most common work visa that, and and most people, this is sort of across all occupations that are considered specialty occupations, but a lot of people do their H1, their residencies on H1B visas. There is a 6-year limit to the H1B, so if you are going to go through a program that will take more than 6 years, then maybe the J1 is the better visa option for you because you're going to run out of H1B time unless you start a green card process by year 5. It is possible to get H1B for residency, but you would have to make sure that the hospital would support that. I understand most hospitals would rather do a J1 for you, but of course there are programs that will support an H1. If you are going to start with an H1 and then transition to a J1, just keep in mind that as part of an IGA waiver process or obligation, you are committing to working at an underserved area or the VA for 3 years, and those 3 years have to be spent in H1B status. So you do need to make sure that you have enough H1B time at the tail end of your, so that you are able to fulfill this IGA waiver requirement. All right, you can file up to 6 months prior to the start date, and there is an option for premium processing, so the process can be much faster. You can have it be completed within 2 weeks, and then when you're going from a J1 to an H1, that could be done if you've received a waiver of your 2-year home residence requirement for working at that underserved area through an IGA waiver or a VA waiver. If you are actually getting a waiver based on hardship or persecution, then it's not. You're not really supposed to be able to change status within the U.S., and you may need to go back to get a visa abroad and then come back to transition then onto the H1B. Okay, other things to keep in mind are that there is a limit to the number of new H1Bs that are given every year. It's 65,000. There's another 20,000 set aside for people who've graduated from master's programs in the United States. There are a lot of people who are not subject to this 65,000 cap count. We refer to these people as being cap exempt, and they include the J1 physicians who have approved waivers to work in underserved areas, so those folks don't have to worry about H1B numbers and whether or not they have to wait until October 1 to start their program. Institutions of higher education, such as universities, nonprofits, and teaching hospitals associated with these universities are also considered cap exempt. So if you're going to be doing your residency program, you are most likely cap exempt and you don't have to worry about the H1B caps. However, when you are transitioning from completing your training, your fellowship, and now you're ready for that attending position and you're going into private practice, you will become subject to that H1B cap. And what this actually translates to is that because there is this limited number of visas, they run out pretty quickly. And since immigration allows you to apply up to 6 months prior, everyone applies within the first week or when the window opens. So the numbers become available October 1, which is the beginning of the fiscal year, and since we can apply up to 6 months prior, April 1 is like the real hot time when everyone files their H1B petitions. And in the last few years, USCIS has received way more than the 80,000 number set aside for every fiscal year, and so the way they've been handling it is that they conduct a lottery, and so they pool together all the applications that are received in the first 5 days, and they randomly select the 80,000, and so the chances of being selected in this H1B lottery aren't that great anymore, because there's such a high volume of applications that are received during those 5 days. So that is something to keep in mind when you are transitioning to the attending position, you're going into private practice. But let's say you are selected in this lottery, then the application would be adjudicated and approved. However, you can't actually start working until October 1st. So there may be a gap from when your program finishes at the end of June to when you can start your job in October. So you may want to have to go home for a couple of months, or you might be able to extend your work at the hospital where you've been doing your training for a few months, so that you can bridge the gap. All right, so the basic requirements for the H1B is that it is filed by an employer. You can't self-petition. You do need to show that you've completed all 3 steps of your USMLEs. You do need to have a license in the state of employment, unless that licensure requirement is waived because you're undergoing training. The physician must also be paid a prevailing wage, and that's determined by the Department of Labor. With residency, there is an ACGME sort of scale that we refer to in showing that that the resident, PGY1 resident, is going to be paid above what is considered the prevailing wage for PGY1 residents, and you're not being compared to other attending physicians. The H1B, as you can see, is quite expensive. These are the government filing fees, and if you did want to go for the expedited handling or premium processing, that is an additional $1,225. This is one of the reasons why a lot of the hospitals or teaching hospitals don't actually want to do the H1. They would rather do a J1. All right, now we're going to talk about how to actually acquire status from to the J1 or the H1, and the two that we're going to discuss is doing a change of status within the United States, or going back to the consulate for your visa. The change of status is done when you're in the United States in lawful status and you file the application with one of the USCIS service centers. It would either be Vermont or California, depending on where you live. You need to make sure that there's no gap from when your current status expires and when your program is going to be starting. So if you're currently in the United States on a tourist visa and you've been admitted only until, let's say, April, so you will need to make, double check your I-94 record, which is the electronic I-94 record. Just see how long you've been admitted until, and if it's any date more than 30 days before your program start date, then you cannot apply to change your status within the U.S. because there is going to be a gap from when your current status expires and when your program will start. If, however, you've been admitted until June 1 or May 15th and your program starting June 15th, that falls within the 30 days, so you should be able to apply for a change of status. But however, keep in mind that there is a lag time from when you apply, so it could take a while for for USCIS to grant that change of status. The other issue to keep in mind is that this issue about fraud and misrepresentation, if you come into the United States on a tourist visa as a B1 visitor or as a tourist, you are presenting yourself as a tourist for a temporary stay and that you're going to go home. If within 30 days you apply to change your status within the United States for residency, then there's a presumption that you had this preconceived intent, and if you do this within 60 days of entry, meaning filing the application, then you have the ability to given the opportunity to explain that that wasn't in fact your intent, but there you do need to be aware of that so that you're not coming to the United States and immediately filing an application to change your status. The other issue is that you just think about what your future repercussions are for a future visa application. There are a lot of U.S. consulates where if you have gone from a tourist visa B to change status to an F1 or a J1 and a future visa application, the consular officer might not be too happy with you because you didn't go back to them to get your visa first. Sometimes they can hold it against you, or they could hold it against a family member who's then applying for an F2 or a J2 visa to join you in the U.S. The consular officer may say, well, you're the principal applicant changed status and hasn't come back for their visa application yet. So that's something to keep in mind. The H1B change of status is again done with USCIS on that petition, which is the Form I-129 filed by your employer. You can request premium processing, but just keep in mind that there can't be a gap in when your current status will expire and when your program will start. The J1 is done by you, and you would submit Form I-539, and you would do this after the ECFMG has issued the DS 2019 to you. There is no premium processing available, and right now Vermont is taking several months to adjudicate the J1 change of status applications. California is reporting about 2.5 months, so just keep that in mind when you're trying to figure out whether or not to remain in the United States and do the change of status, or just go home and get your visa. And also, if you are going to stay in the United States and do the change of status, what that will mean for any future trips back home, because eventually you will need to go to the consulate and get a visa stamp if you, if you leave the country and you need to come back. All right, so for consular processing, you can apply in your home country, or you can apply as a third country national in Canada or Mexico. Actually, let me go back a little and mention that if you are going to go to one of the U.S. consulates in Canada or Mexico, they typically don't like it if you're applying for a new visa there. So if you had a tourist visa, B1 visa in your passport, and now you have a DS 2019 and you want to apply for a J1 visa, they probably won't accept your application in Canada. They'll say you have to go home because this would be your first J1 visa. Now, if you've already been issued a J1 visa and it's only for 1 year, and you've received your new DS 2019 form for your second or third year and you want to get a new J1 visa, then you can go to a U.S. consulate in Canada or Mexico, and that would be considered a visa renewal application, and that should be fine. But for your first initial one, you do need to go to your home country and apply for the visa there. Some things to consider is the security checks. So the Visa Condor is the most common one, and it's if you come from a predominantly Muslim country, or if you're from one of these high sort of concerned countries, that may trigger a security check. These security checks are cleared within 2 or 3 weeks, but some of them can take as long as several months to 2 years. The Mantis is more for the sensitive technology. We've seen Indian and Chinese-born nationals being hit with the Mantis. And these are more for people who are in the sciences, and they want to make sure that they're not working on any sensitive technology that could be exported out of the U.S. And so for that one, you would have to show that this is the knowledge that you've gained or you're working on is in the public domain. There's nothing highly sensitive about it. These are some other security checks. The donkey or the NCIS, these are more the donkey is where there's a potential match, and this one really can take a very long time, and it's often a case of somebody's name matching with somebody else in the system. The other one is when there's a criminal record, then if you know you've got that, then certainly bring your documents with you to the interview and show that that the matter has been settled, that it's not dismissed or has been resolved. You paid the fine, what have you. All right. If you are hit with a security check, then you can follow up. You can have an attorney inquire for you, or you can also seek congressional assistance. And for the congressional assistance, that one may be more effective if you have your program director or the hospital seek congressional assistance, because they really fall within the jurisdiction of that congressman's office. Another issue that that could potentially create a delay when you're applying for your visa is if you're coming through in a petition-based category such as an H1, if you go too soon after your petition is granted, it's possible that that it hasn't been uploaded, the petition hasn't been uploaded in the State Department's information system. So they may say that, we see you have an original approval notice, but we need to verify it within our system, and the petition's not there yet. So they will then need to contact immigration and the KCC to have it uploaded so they can confirm the information that's in the petition, and then at that point they can issue the visa. So this type of a delay can can result in at least like 4 or 5 days, maybe a week, until the petition is uploaded and they can verify it. The good thing about PIMS, though, is that you don't have to have an original approval notice anymore. You can go with a photocopy because they have to independently verify the validity of the veracity of the petition through PIMS. Okay, now if you are denied the visa, then you're supposed to get a denial letter from the officer, and we would see if this is 221G or 214B. So the 221G is more where you're missing a document. Sometimes if it's a security check, they will still say that it's a 221G denial. It's really not. It's just that they can't issue the visa until the security check clears. The other one, which is a 214B, this one you would see more often with a J1 visa application, and this one they're just not convinced that you're going to go home once your training finishes. So maybe you didn't have enough evidence of ties to your home country. You can also always request reconsideration, apply again, but just keep in mind that if you are refused a visa, then it would affect your ability to come under ESTA, which is the visa waiver program, or apply for a future B visa. And then with regards to expediting security checks, we have been successful in requesting it. Normally you would provide a letter from the program, from the hospital, saying how critical it is that you are able to start on time, that it affects their patient care, things like that. So you can show that there is a humanitarian reason for having your visa issued, promptly, so that you can come in and resume your job or start your job. Another issue that you should keep in mind is that especially if you're from a country that's considered of concern, such as Pakistan or one of the Middle Eastern countries, we have heard of stories of people having their visas revoked or going to the consulate not being able to receive the actual visa stamp. So if it is discretionary travel, then just something to keep in mind is whether or not to take that risk and travel, or just stay in the United States, finish your training straight through, and then think about it. Because if there is this type of disruption where you cannot come back or your visa is revoked, it's really difficult to overcome, or it can take a very long time, and you may lose your contract with the hospital. So just something to keep in mind. And these are just other, categories of people, just to keep in mind that, you know, if you are weighing whether or not to go back and get your visa and make that trip home, these are some issues that you should keep in mind when making this type of a decision. All right. With that, I'm going to finish my presentation. I did want to now open it up for questions. So if there are any questions, you know, please do post them, and I'll see if I can answer some of the questions now. You can also email me or call me with any follow-up questions you may have. So I'll wait a few minutes to see if anyone has any questions. Okay, it doesn't look like there are any questions, so we'll end the presentation here. But you do have my contact information, so feel free to call or email me. If you are based in the West Coast and would rather speak to someone in our California office, the phone number there is 310-570-4088, or you can reach us through that 1-800 number. Thank you so much.